Contracts. The unsung heroes of business. Let's talk contracts, folks. Not the sexiest topic, I know, but in the business world, they're the glue that holds everything together. Think of them as the legal backbone of your deals, ensuring everyone plays by the rules. From hiring employees to sealing multi-million-dollar mergers, contracts are everywhere. And understanding the basics can be the difference between a smooth transaction and a legal nightmare. Now, you might be tempted to download a template from the internet and call it a day. Don't. Each business is unique, and your contract should reflect that. Relying on generic forms is like playing Russian roulette with your company's future. Trust me, the potential consequences are not worth the risk. So why are contracts so crucial? For starters, they clearly define everyone's rights and obligations. Think of it as a roadmap for your business relationships, preventing misunderstandings and disputes down the line. A well-drafted contract can save you a world of headaches, not to mention legal fees. But contracts aren't just about avoiding conflict. They're also about building trust and fostering strong business relationships. When everyone is on the same page from the get-go, it creates a foundation of transparency and accountability. And that, my friends, is good for business. Let's break down the basics of contract law, shall we? First up, we have contract formation. For a contract to be legally binding, it needs a few key ingredients. We're talking offer, acceptance, consideration, and a mutual agreement to be legally bound. Think of it as a recipe for a legally sound agreement. Next, we have breach of contract. This happens when one party doesn't hold up their end of the bargain. Maybe they missed a payment deadline, or perhaps they delivered shoddy goods. Whatever the reason, a breach can trigger a whole host of legal remedies, from financial compensation to even terminating the contract altogether. Now let's talk about contract interpretation. Sometimes disputes arise over the meaning of certain clauses. That's where courts come in, acting as referees in the game of contract law. They'll consider the plain language of the contract, any past dealings between the parties, and other relevant evidence to figure out what the contract actually means. And don't forget about third-party rights. These are situations where someone who isn't a direct party to the contract might still have some skin in the game. For example, think of a beneficiary designated in a life insurance policy. Even though they didn't sign the contract, they still have enforceable rights under it. Finally, let's touch on contract defenses. These are legal arguments that can be used to invalidate a contract or excuse a party from performing their obligations. Think of situations like fraud, duress, or even a good old-fashioned mistake. If any of these defenses fly, the contract might be as good as toilet paper. Drafting a solid contract is like navigating a minefield. One wrong step and you could trigger a legal explosion. So, let's shed some light on common pitfalls to avoid. First up, ambiguity is your enemy. Avoid vague language like the plague. Be crystal clear about every term and condition. Remember, clarity now can prevent a world of pain later. Next, don't overlook crucial terms. Think of your contract as a safety net. You want to make sure it covers all the important stuff like warranties, indemnities, and dispute resolution mechanisms. Leaving out essential provisions is like forgetting to pack a parachute before a skydive. Another common mistake is failing to consider risk allocation. Contracts should clearly outline who's responsible for what, especially when it comes to potential liabilities. Don't leave this to chance. A well-drafted contract will allocate risks fairly and protect your interests. And finally, pay attention to detail. This might seem obvious, but you'd be surprised how often careless errors creep into contracts. Typos, missing signatures, incorrect dates, these seemingly small oversights can have major consequences. So, triple check everything before you sign on the dotted line. Signing a contract is just the beginning. Effective contract management is an ongoing process that requires vigilance and attention to detail. First and foremost, always do your due diligence. Before entering into any agreement, thoroughly vet the other party. Check their reputation, financial stability, and track record. Once the contract is signed, don't just shove it in a drawer and forget about it. Regularly review your contracts to ensure they're still relevant and aligned with your business goals. Laws change, markets evolve, and your contracts should adapt accordingly. Remember, building strong relationships with your contracting partners is key. Open communication and mutual respect can go a long way in preventing disputes and fostering a positive working relationship. Sometimes a simple phone call can resolve an issue before it escalates into a legal battle. And finally, never underestimate the value of good legal counsel. Lawyers might not be cheap, but they can save you a fortune in the long run. Consult with an experienced attorney throughout the entire contract lifecycle, from drafting to negotiation to enforcement. Trust me, having a legal eagle in your corner is worth every penny.